teachers and students, and anybody interested in American government, the Constitution, and American politics. Welcome to the 4Bs. We're happy to see you during what for some of us is spring break. And here in California, today was a beautiful 81 degrees. And I understand that in the Great White North, they got some snow yesterday. And of course, Dr. Williams lives in paradise in San Diego, where it's always 73 degrees and pleasant. So anyhow, so welcome. Today's session, we're going to be talking about the debate on the Bill of Rights and some other issues related to that debate over the Bill of Rights and the Bill of Rights through the ages. And I want to start off with a question to kind of all three of you, because I don't know if it's more of a political science question or a history question, but I was intrigued and doing some of my reading this week and this may be a pretty inane question, which I'm pretty good with, but is there? Well, here's the definition of bills of rights. A bill of rights, sometimes called a Declaration of Rights or a Charter of Rights, is a list of the most important rights to the citizens of a country. All right. So, given that definition, are we to conclude that Bill of Attainder, ex post facto, habeas corpus are not amongst the list of America's most important rights, since they're not in the bill? And I guess my question is there a distinction between rights and bills of rights? Or am I just being, so anal retentive here that I'm trying to find something that doesn't exist? And
that paragraph, David, is anything but inane. First of all, I would say actually the opposite to your first question. Because they were in the Constitution and they came out of the convention, they do fit the category of the most important ones. And that's actually what the Federalists said when in trying to answer the Anti-Federalists for a formalized list. So they said, we got the ones that have been the most important to us. So it wasn't, so in that case, it's the reverse of your question. Now, the other thing I would suggest that what I would hear in your question is the definition is there's a relativity from society to societies as to what they value. And bills of rights are always kind of a product of their time period too, what shows up in those listings. So.
Chris or Mike, is there a distinction? I mean, I'm just looking at this term bills of rights versus, again, going off Tim's, and my question, but given these rights enumerated, but they're not lists, they kind of stand alone in certain segments of the Constitution here. So is it just semantics?
I think it's just semantics, honestly, because I don't think you separate whatever you want to call them, a bill, a listing, or baked into the cake, so to speak. I mean, I think when you define constitutionalism, one of the definitions of constitutionalism is it also provides a protection for specific rights for citizens. And so I just think of the ones you listed, David, and as Tim said, what the framers put in because they've considered them to be maybe the most important for various reasons. As just as important as a listing that comes afterwards, because we know had Madison gotten his way, those rights would have been embedded in the document itself. I think it was Roger Sherman, I think, that talked him off the ledge and said, no, we don't want to try and put these in the body of the Constitution because we'll have to go back and re-ratify. So, we got the tacked on at the end Bill of Rights simply because they didn't want to mess with putting them in the body. So.
And a lot of the colonial charters, they did call them declarations of rights if they were separate. Now, some of them weren't. I think my first recommendation for the night is for kids to look at the Pennsylvania, I think it was called the Charter of Liberties.
Yes.
Now, to our modern ear, I think most people will hear, oh, well, that's a Bill of Rights. But if you look at it, it's really cool because there's a preamble written by William Penn. It's almost like a religious rationale for a social contract. Then it gets to the structure of government. And then at the end, there's the statement of I think upwards of like 40 or 50 rights that they list, but they call it a Declaration of Rights. So I would agree with Chris that it doesn't seem to be much of a difference between whether it's called a bill or a declaration, or where it appears within the document too.
Yeah, I would agree with that. But one thing to look at, in the South African Constitution, they make the amending of any Bill of Rights harder to do. So I can't speak for what other constitutions do, but I know there's one case where they say, okay, to amend the Constitution, you need to do X, but to amend any Bill of Rights, you have to do more, right? They're making it more difficult because they want to make sure that those rights are treated as fundamental in terms of the power politics of what can happen in parliaments. So that's really, yeah.
I'm sorry for clarification. So you're saying that, so it's one thing to amend maybe, how many representatives or something like that, but they make it more difficult when you start talking about what they consider to be the fundamental rights, make it more difficult to amend those?
Exactly right. Yeah, in their Constitution, Section 2 is their Bill of Rights. And so the amending process speaks to any amendments to Section 2 go through a different process.
So they do that kind of constitutionally. Is that embedded in their Constitution? I mean, there's a clause, if you're going to do this.
Yeah.
So do we not do that culturally, given the fact that we have really never amended a right in the Bill of Rights? I mean, we've talked about it, but I'm just wondering if we don't do it necessarily, Mike, as if we've embedded language that if you're going to play around with these first 8 amendments or 9 amendments, we're gonna create extra constitutional procedures or whatever. But I'm just wondering if culturally we've kind of have this attitude, at least since the early 20th century. We just don't play around with this. What do you guys think?
I think culturally we have a history of state sovereignty. I mean, I think the idea that we have this two process, right? It needs to go through states. In South Africa, it doesn't need to go through the provinces. It's just 75% of the parliament. So I don't know if culturally we've done anything. I just think it's really hard. The framers made it really hard to amend the Constitution.
And I don't know that we need to, because we have, our judiciary has kind of assumed a role in some of this, and especially with the principles of substantive due process. Now you use the word amend rights, David, but I might suggest that students consider, when all things said and done, is there any difference between amending a right, as you've described, David, or the court just discovering, creating, or elaborating on a right? I don't know that there's much difference where the rubber meets the road on that.
Well, when I think about amending the way that Mike was talking about it, is I'm thinking of going the other direction. If we wanted to make more restrictions on individual liberty, that takes a supermajority in South Africa. Again, we've had some discussion in our nation's history. We're all aware of especially maybe with due process rights there. If we consider the 14th Amendment's enumeration of rights as an extension or another, its own self a bill of rights in one sense, we're having that conversation today of taking away birthplace citizenship, kind of thing. So that's where I'm thinking about it, Tim. Is your right to a greater degree, at least in our time, there's been this judicial interpretation expanding the notion of these rights,
or contracting too. I mean,
it'll be interesting.
We do the same thing with time, place, manner. So to your point of limitations, we still seem to be comfortable with doing it judicially. if we want to limit, because I think Chris said the last time we met, there's no such thing as an absolute right. Nobody wants to live in that world. So we have to figure out where the edges of it are. And we've, for better or worse, it seems to me we've relied on the court to either expand or limit our rights.
But and to support, David, the idea of culturally, and to also support what Tim was saying with the court, I always talk about Brown, from Plessy to Brown, so you're looking at what, 58 years, nothing changes. We don't have any new laws. We have no new amendments. But what has changed? We know the makeup of the court has changed. We know that we have changed. Romer v. Evans, Bowers v. Hardwick, right? And then you get to Lawrence v. Texas, and then to Obergefell. We have no new laws. We have no new amendments, but we see this expansion of rights to different groups. It comes from the culture that we live in, and the court changes. So I think that, we don't necessarily, I don't know, we're discovering rights or discovering more groups are entitled to these rights that have been denied these rights. But I think that it speaks to what you're talking about, David, culturally, and to what Tim is saying, and relying on the courts to do this. And now we see, at the state levels, we see, state legislatures trying to restrict certain rights. So.
Yeah, and we want to get to that in a bit. So, in that debate over the Bill of Rights, just to cover some fundamental ground here, the Federalists said that a Bill of Rights was a dangerous proposition. Is that hyperbole, or did they sincerely believe that this whatever list they come up with was a dangerous proposition? And that probably is in your strike zone there, Mr. Moore.
Yeah, it's hard to keep a straight face, I think, if you're a Federalist making the argument as to why we don't need a Bill of Rights. But because, the Jefferson quote is very prescient on this. Holy cow, we've had a whole, British Anglo tradition of rights being stated by all kinds of entities. So yeah, I think the Federalist argument on the Bill of Rights was, I would see it as weak all the way to disingenuous at times. So yeah, that would be my answer to the Federalist argument.
Wow, Tim, weak and disingenuous. Go ahead.
I do,
Chris.
yeah.
Well, my question is kind of a follow-up and more for Tim, and see how this relates, because I know at the convention there's a discussion about protecting the freedom of the press, right? So they're going to say, well, we should put this in it. We're going to protect press freedom. Yep. And then the argument becomes, well, if we say this, does this mean we believe that we had a right to restrict it? Well, we don't have a right to restrict, or we don't have the power to restrict it. So therefore, let's not even touch it. So that's always strikes me as an interesting argument.
Well, you're right. That was, and the person I think I would urge kids really to look at on this is James Wilson. We've talked about him before. He made a couple of very interesting speeches, one on October 6th. We'll paste it in the presentation for you. But he makes this argument that, hey, it's not listed, so therefore it's nothing. It's retained. It's a retained right if we've not stated it. Now, I think it's interesting the quote that's in this question for students to consider. There's this where Jefferson says it's risky to not have a Bill of Rights to
inference.
And leave it up to, I think the word is something like inference or something like that. And that is a direct critique of Wilson, because Wilson gets beat up very, very quickly by anti-federalists for making this, you still have it, we don't need to list it type argument. So Jefferson, the way I read that quote, he's addressing that whole Wilsonian argument of you relax, you have it, we don't need to list it. It's a retained right. So I think students really should read the October 6th of 87 and November 24, when Wilson is in the convention in Pennsylvania. He makes a very similar speech about this idea of And federal, hardly any Federalist comes to his defense too, by the way. And he's attacked for a year and a half all over the country for this argument. So he becomes kind of the punching bag for anti-federalists to really go after him on this. Gee, you forgot a Bill of Rights, and don't try to tell us it's a good thing type argument.
Well, and I know I'm walking into a landmine here, but I take exception with, and I think you've already made some arguments, and Chris as well, combating your view that it's disingenuous. First of all, they have put rights in the body of the Constitution, in which, and I think Chris was talking about this, which are commensurate to the powers that the national government's going to have. And I got to believe that they have a general idea based upon state constitutions of what kind of rights they're talking about adding to the Bill of Rights. And the one thing I'll agree, partly to your commentary, Tim, is there's obviously a very strong political element here, especially by Madison, that if we open this up to a discussion of Bill of Rights, the anti-federalists are going to try to undo whatever has been done.
Yeah.
That part I'll accept.
Yeah.
But I don't think the arguments are disingenuous, because I think history seems to play out. Those rights that they finally come up with have no relevance to American political society or constitutional society for at least the first 80 years.
Well, but we all have the luxury of looking at it 200 plus years later. But also, one other thing I would suggest. Now, I would suggest too that some of the arguments that Federalists have to make about why they don't need a Bill of Rights is because they're also scared to death of other kinds of amendment proposals that are happening. There's not just the proposals coming from these state ratifying conventions that are, hey, add these rights. Many of those guys are scared to death of other amendments like structural amendments. So I think some of to defend myself against these outrageous slings and arrows that David is hurling at me, they're scared to death, not in addition to making the argument about rights, they don't want to open up any amendments because it may open up structural amendments in a second convention and all of that kind of stuff. So there's another kind of amendment that I think factors into their arguments. We don't need rights. They're scared to death of other amendments as well.
I just, I would agree, because I think Madison for sure was very worried about that, that whole idea of the structural changes. I don't think he was worried per se about listing rights. But I think it was the structural changes that will come in that scare the bejesus out of the Federalists. So that's why I think they were not entertaining those to begin with. But then again, that also explains why Madison, I hate to call him a flip-flopper on this, because I don't think he really is. But, the guy that's, Jefferson writes this quote to is to Madison, and there's back and forth about, it's nice, but, you could probably do it with the Bill of Rights. And Madison's like, well, no, we don't need them, and this is why. And then Jefferson comes back, and in the series of letters for the students back and forth between Madison and Jefferson. But I think that, this is where you see Madison finally say, you know what, I think I better do this for various reasons. There are several reasons why he does this, but one of those is to protect the Constitution.
Yeah. Well, even in his speech in Congress, when he's, and I'm going to propose these following rights, even in the speech, he says, because I'm afraid to and he puts lipstick on this, that legitimate, but he also says, I don't want a second convention. He actually says that in that June 8th speech. So I guess maybe disingenuous is a little harsh, but I think I may stick with that statement. I may stick with that. What has happened? I'm like, this is the second week in a row I'm the curmudgeon. I looked at some of the one from last week, and I'm like, man, I was kind of a knob there.
No, Kavanaugh is on your side, and right now the political scientist is staying mum on this. So let's let's play this game. All right, let's go back in time and let's change, some of the facts. Let's assume for a moment, just for the sake of argument, that the Federalists win and there is no Bill of Rights. All right, so I'd like you guys to map out for me your viewpoint of how does constitutional history then play out? Does it play out any different, in your opinion, if indeed we don't get those 10 amendments, or at least the first 8, 9 amendments? Does constitutional history play out differently?
I'll go first, but this is going to be bad. So I'll let you guys clean this up. You guys get to walk behind the parade. I'm going to say no. I'm going to say it doesn't matter till you get to the 14th. I mean, I don't know that any of those things really matter till we get to 14. And I know that we kind of had this discussion with Hank, right? So I'm going to say no. So sweep up the.
No, I would agree, Chris, because there's enough. I mean, there was this weird thing that happened in the founding period in the 1780s, where New York made this statement to the Congress, the Articles Congress. The Articles Congress had proposed an impost, and the New York legislature issued a statement to the Articles of Confederation saying, yeah, we can go ahead with this impost, but it will be evaluated in our courts by our Bill of Rights. What they essentially, think about the weirdness of this. They were attempting, in my estimation, onto a national government. They were putting severe restrictions on the kinds of legal procedures, courtroom procedure, all kinds of stuff in New York. So I think, to Chris's point, I think there's enough rights in the constitutions of the states that would have been fertile ground to be used as leverage against the national constitution through kind of a weird reverse incorporation. Now that's conjecture, but I think, to Chris's point, that there's enough going on pre-14th Amendment that we may have gotten there faster, frankly.
Maybe.
Mike?
No, I agree. I agree but to say it doesn't matter up until the 14th is still saying it matters a lot that they're in there after the 14th. I mean, after what the court does to the 14th and privileges and immunities, if they're not there after that, I think then constitutional history looks a lot different.
Yeah.
Before.
Yeah.
Well, one could argue that we could have, if you start to look, all right, especially get low afterwards. That's when the revolution happens. You've got major cases in the 19th century that deal with the 14th Amendment, the Equal Protection Clause, all right, which is, again, has nothing to do with the Bill of Rights itself, but the rights issues that we have fallen in love with in those Bill of Rights really doesn't start to get low. And I would argue that you could have made those same decisions without the enumerated rights themselves. All right. Again, thinking that possibly without an enumerated list of rights, the Privileges and Immunities Clause increases in its importance in post-1920-25, and the court could articulate those because inherent in liberty is equality. We hold these truths to be self-evident that all men are created equal, and they are endowed by their creator with certain unalienable rights. So equality and liberty, to me, are implicitly tied together, and that the court, even without this list, would have gotten to these same questions, all right, in this emerging nationalism of rights, post-World War I.
That's a great way to say that, David. Professor Danielle Allen, in her book, Our Constitution, lays out that kind of very argument about equality, talks about equality on about 3 different levels, but it sounds like you were just simply articulating what she had said. So I think that's well said. And I think that makes for an interesting kind of a what if kind of proposition. But it's kind of,
and again, my intent is to go back and slap Mr. Moore around for, again, going after my Federalist buds, that they were disingenuous and, that kind of thing, because in so many ways, I'm sorry, their arguments tended to play out. there. Because again, one of their major arguments is if you list, all right, you're going to leave things out. Now they try to cover their backsides with the Ninth Amendment. Well, how well has that played out in history? We have no particular singular reference to the Ninth Amendment in our entire constitutional history. It's thrown in there with, with a conglomerate of arguments, but there's no singular. And my understanding is that's their way to deal with this enumeration of rights. And so we're now locked in to amendments 1 through 8 because you have, in some ways, this silly notion of original intent, or not original intent, of literalism that goes on. To me, that played out in history there. So part of me is trying to, mainly because I anticipated where Professor Moore would approach this from. I think the Federalists are absolutely right that this is a political ploy by the anti-Federalists. The anti-Federalists, if anything, are lacking sincerity. I think that once the first Congress gets together, we see that they're lacking sincerity about, we need a Bill of Rights there, and that the Federalists, at least as history played out, had a better argument.
I don't know. They're just so. I mean, I looked over some of the colonial charters and statements. Another interesting one is the Massachusetts Body of Liberties. I mean, there's like 98 rights. Some of them for animals, for women, for servants, slaves. I mean, there's such a fertile. The fields are just littered with all kinds of rights in our history, and I have to believe. Well, I don't have to, but. There's just so much to mine in our history of rights for them to eventually be brought to the national level. They're just all over our history. So it just is and that's the anti-federalist argument. You know, we're kind of a rights people. We have this legacy. So there's a lot there to be mined, I think, if we hadn't had the list. And by the way, to another one of your points, David, I think we haven't had to rely on the Ninth because we chose the route we did by gutting privilege and immunities and pouring it all into due process liberty. So due process liberty has kind of functioned like the Ninth in the hands of the court.
Well, other than privacy, help me out on that. Where has that enumerated another right other than privacy? Isn't privacy the only right that they've enumerated?
Well, I mean, you get to the bad when they apply property rights and personhood to corporations in the late 1800s. I mean, they do some wacky stuff, interpreting liberty of contract in Lochner. So they do some crazy stuff through judicial interpretation. And whether that's full blown, it's not personal rights in corporation. It's like corporate rights in corporation.
It's also they found the right to travel, right?
Yeah, right.
Using the due process, yeah.
As opposed to privileges and immunities, which it should have been.
Right.
I mean, it should have been.
Well, just to throw one more thing in for the students to think about if there were no Bill of Rights, and we've talked about this on previous episodes, but the preamble, secure the blessings of liberty. So there's an argument to be made that what are those blessings of liberty that we are founding for ourselves? That seems like that's another, to get to Tim's idea of a fertile sort of spot, right? Where you could say, of course, liberty would mean this. And of course, that's something that the first thing we say to ourselves as a country, that we're creating this constitution to secure these. So of course they need to be named. So
using Chris's, little metaphor of I'll lead the parade and you guys clean it up here. I think one of the best arguments that Madison articulates is this notion of parchment barriers, that bills of rights in and of themselves are useless. And I think we've all, I'm pretty sure that Kavanaugh has had dealings with police in his youth. I'm sensing that possibly
that's been expunged. So
yeah, the only one I have no idea if Professor Williams has had any entanglements with police officers, at least in the United States, possibly in foreign countries. he has.
Midnight Express.
The first bullet question, it threw me for a loop, and I don't want to insult the question. I can see some basic elements to it, but it seems to me there's neither an advantage nor a disadvantage of national versus state bills of rights, because in the last analysis, bills of rights have really very little relationship to protecting your liberties, because Madison was absolutely right. It's the structural separation of powers, checks and balances, federalism, judicial review. It's in those structural procedures that rights are protected, not in a Bill of Rights. See, we all know you get pulled over by the cop and you say, hey, or for Chris, since he carries his pocket constitution with him all the time, hey, I have this right here. The cops, because I've tried that, by the way, with a police officer, the cop's just going to laugh at you. And right, and we are just inundated with, every day with cases where, in which the state kind of chuckles when somebody says it's my right, there. So what do you think? I mean, how do you feel about this question of advantage, disadvantage, when in the end, bills of rights, they're pretty, they're romantic, they make us feel good. Maybe they have an educational purpose, as Jefferson talked about, but in the last analysis, they don't protect our liberties. Who wants to clean up?
Well, I think there's some truth to that, but I think there's also, it's nice to, I'm not like the flying Walendas. I like to have a net. So I like to have that net there, knowing there's a backstop. So, I don't want to get all serious, but I think we see it playing out in Minneapolis right now, right? When the George Floyd trial is just starting. Now, I don't know how that would relate to the Bill of Rights, but certainly, the idea of certain protections that would need to be there. So I think of the Bill of Rights as that backstop, so to speak. So if separation of powers, checks and balances, and those things don't work, then I'd like to think about that. And I think Madison's alluding to parchment barriers because of the Treaty of Paris. Loyalists were not getting their property back. You can also see, Article 1 contracts. They protected contracts in the body of the Constitution because contracts weren't being honored at the state level. So, I mean, those are his allusions to parchment barriers with those rights like that. So they kind of clean that up in terms of the supremacy clause and
well, Chris, I'll add in. He's also sees the Virginia situation with religion too, where the Baptists are getting beat up pretty bad. So it's more than just money stuff. It's also religion stuff for. And that on the whole mid 1780s. So.
Yeah, I would just add. I think the way the question reads to me, it's like, what would it look like if we had 50 different sets of bills of rights that had different things in them from state to state? Okay, it's going to look a little messier. We kind of have that already. So there's a reason why, like Chris was saying, that this, I think you called it the floor, the safety net, I guess.
Yeah.
I'm just wondering, and someone's going to have to clean up after me on this one, see where this argument goes.
Be a messy parade.
Yeah, it is very messy. But just in terms of our own national identity, and this is where I think we could argue it's been an advantage and a disadvantage to have a national Bill of Rights. Most Americans think America is special not because of separation of powers. They think we're special because we have the right to have a gun, or we have a right to freedom of speech, which means I don't have to wear a mask, right? When it seems like those are the things that we pull out when we want to say we're proud of ourselves as a country. It's not the structure of the system, it's the Bill of Rights. And I think you can make an argument how that's been an advantage and a disadvantage in terms of building our own national identity. To what we all have in common. Because if we all had 50 different sets of rights, it's going to be even harder to build that maybe sense of Americanness, maybe.
Well, we still do, Mike. We still have 50 sets of rights consciousness in this country, which is, as you say, it's very messy. And it also makes you a slave to geography. Your rights are determined by where you live. And again, I'm still hearing this. If you don't like it, move there, whether it is privacy rights and reproduction, whether it is identity rights and gender, and again, we're still, it's 2021 and we still do not have a national set of equality rights for gay and lesbian. You can still be, you don't have job protection, and some school districts you don't have protection. So to me, I guess if I'm going to answer this question, relying on 50 state bills of rights, is ludicrous. If you're going to have a nation, if you're going to have a confederation, then that's fine.
Well, yeah, but to Mike's point, I think if your identity is based upon the possession of rights, and Mike might be right that we see ourselves as Americans because we have those things.
But that hasn't always been true.
Right, exactly. And that's why I think the National Bill of Rights I would consider it to be a minimum, a minimum standard, like a floor, I think is what political scientists call it. I would urge students to look at, I looked at the Wisconsin Bill of Rights today in prep for today's session. And there's some really, we have the right to hunt and fish. And speaking of identity, how more Wisconsin can you be? There's a right for religious groups to meet in public schools, for Sunday services. There's all kinds of interesting little quirky things in state bills of rights. Now, do these are those essential to the scheme of ordered liberty? I think there's an honest argument there that they may not be, but I would urge students to look at pick 10. If you got a panel of 4 kids, each take 2 states and look at them and do a little comparison discussion. Would there be an advantage or a disadvantage to having, Wisconsin's Bill of Rights as the standard, or just kind of those thought processes comparing other states' bills of rights?
I looked at North Dakota's today too, and it's funny because I asked my class of my A-push class, and none of them had ever looked at it.
Right.
So the idea is that this kind of backs up what Mike was saying in terms of, what people think about America is I got a right, right? That's my rights, right? But when they talk about that, they rarely, I don't think, David, I think they rarely rely on their state Bill of Rights because so few people actually know those.
Yeah.
And North Dakota has some very much like hunting and fishing. My question, Tim, is the right to eat cheese curds, is that protected, or? We're
working on that. It's got to pass the legislature 2 sessions in a row, but I have recommended it.
Okay, good.
Well, I just want to add one more quick thing, because I just think students should think about this as well. Chris has really talked about a lot how we don't have any absolute rights, but that's the language we use. And then Tim, you mentioned early on that what the framers really thought was going to protect rights was the actual structure of the Constitution itself. So it seems like the way a lot of Americans who don't understand the history or the Constitution, they have it completely backwards.
Right?
Kind of like, we have these absolute things, but no, we're protected because our government is structured in a way, right? So that it's a completely reversal of what the framers had intended, how rights should be thought about. So I just find that interesting.
Yep.
So I am curious, Tim, is the right to hunt and fish, is that a positive right in Wisconsin or a negative right? What's the language of it?
It depends on if you're a deer or a human. For the deer, it's a negative right. All right.
Okay, you're going to confuse the students now on positivism and negative. Good.
Well, yeah, I was going to say that'll really muck the whole thing up on positive and liberty. I don't know. I don't know how much it's been adjudicated in the state as to get any judicial interpretation of what these things mean. But the mere fact that an addition, and it was an addition, I think, in the 90s, hunt and fish, in Wisconsin, it has to pass, it's got to pass the legislature twice, and pass a referendum. And so, I mean, who's granting? Is a government granting the right if it passes through the legislature twice? Are the people affirming what they believe when it goes through a referendum? That would kind of maybe make it more in the negative liberty zone. If the legislature's passing it, maybe it's in the positive liberty zone. So I don't know. I mean, it's a good question, but as with most things, I don't know. When you look at the details, whether it's a nice clean division of positive and negative.
There has to be an election between those two state legislatures too, right?
Yes.
Yeah.
Correct. Yes.
Well, in you mature, states out here in California, yeah, we don't do it that way.
Just let the people decide. Just let the people decide.
Too much democracy, baby.
Yeah, and let's.
One of my favorite ballot initiatives for the state of California to use with my students is when you guys got to vote on whether or not there should be a law that requires male porn stars to wear a condom when making X-rated movies. So you let the people decide that in the state of California, right?
No, that wasn't a statewide initiative. That was a LA County initiative.
Okay.
There, I'm pretty sure, wasn't it, Mike?
Mm-hmm. Yeah, it was LA.
It was.
Why would you admit to knowing that?
Because it was because I'm with Chris. It was a great teaching moment in class.
Okay.
All right.
Get people's attention.
Tim, there's a lot of reasons I hate LA, and so I keep all of them in mind just so I can figure them out.
Okay. San Francisco Giant fan. How many schools are we going to rename? And by the way, should we take Cesar Chavez off his school names? Again, if you've read some biographies, never mind.
How about those Bill of Rights?
Yeah.
Back on track.
Well, real quick thing, I have a broad question, but more are there any, we like to say in a lot of our textbooks that, we're negative constitutionalism, we're restraining government, and we talked last time about habeas corpus and, is it an affirmative right or is it a restriction? Are there any positive rights in the Bill of Rights or Constitution in our system? And the only one I can think of is the right to an attorney. Would that be a positive right?
I think
there's all kinds of government commitments in the due process steps. I mean, government's got to act all over the place in amendments 4 through 8. There's a lot of government policy that makes those things true. So I would say 4 through 8 is almost borders on almost all positive liberty.
Really?
Yeah, I would.
Self-incrimination's a negative. It's a restraint on government.
Yeah.
Search and seizure is a negative, isn't it? A restraint on government.
Yeah, but by the time you get to 5, 6, 7, I guess to hone it in a little bit, I would say 5 and 6.
Well, I see. I even say with 4, it's both, because it's certainly you're secure. You have the right to be secure in your person's house's papers and effects, right? So there's a security built into that. So I do have that positive right, but also it's a negative right in terms of the government must, have a valid warrant, these warrant requirements. So I think there's a combination within the 4th, honestly, if you drill down.
Well, Professor Williams, you're the one guy who actually went to law school. The 8th Amendment requirement for bail, is that a positive or negative? Is that a restraint on government, similar to habeas corpus, that, they just can't, keep you in jail because you've been accused of a crime? Or is that a positive right that they have to, they don't provide you the bail. I'm wondering about that.
Yeah, I guess, maybe we've already done this, but, just for the students, like, we talk about positive rights, we're talking about things the government is required to do for citizens, versus negative rights are just things the government cannot do to citizens. So that's like the First Amendment's the easiest one for me to get my head around, right? Congress shall make no law abridging freedom of speech, but Congress doesn't have to give you money to start up your own radio station or something. So I want to make that distinction. 8th Amendment, I read that as it would be a positive right if it were the government will provide access to those who need funding to get out of prison, right? Like it would be giving them the resources for if you don't have to spend time in prison, if all you have to do to get out is pay bail, I think that's articulated there as a negative right. I would agree with what Chris and Tim said about 5 and 6 in terms of even speeding public trials, all that kind of stuff. Those are things the government has to do once you're in the criminal justice or civil justice system.
Mike, where do you see I mean, we've seen this right now in our criminal justice reform system, people trying to do this and doing away with cash bail, right? The whole premise of cash bail and the inequality it put in society. So where would that fit within what you were just saying about bail?
Gosh, I don't know enough about those. I don't know enough about those revisions about they want to get rid of cash bail.
No, I'm talking. Yeah, the idea that
Right.
because
But
Well,
then,
in California, you get rid of cash bail. The county jurisdictions would then set up a special, I guess, process. And I don't know if it's in the DA's office or it's a combination of a district attorney, a judge, and maybe the public defender, a committee kind of process to then make an evaluation of that individual and whether or not cash, whether or not bail should be denied. They should be able to roam, relatively freely until the trial. So there's this new entity that would be created that would do an evaluation on each individual to determine whether or not that they would be released before trial.
yeah, I mean, I think those revisions are trying to move it towards something that looks a little more positive. To me, they're trying to get at like it says, excessive bail should not be required. And that to me is the built-in, that's meant to be the restriction on government. Like you can put a bail on, just not excessive. And these revisions are meant to be like, we need to reevaluate what we're thinking as excessive because that's going to land differently for different communities. And is that fair?
So can I ask you guys this, is this positive negative distinction just a byproduct of context and history? That is 18th century thinkers, constitutional writers, the notion of positive rights isn't really in their vernacular, or am I wrong on that?
Well, no, common law is all positive rights. I mean, the fact that the Parliament states this stuff as a right that emanates from a declaration or a statement of a government, of a parliament. So in a way that there's the common law has all kinds of affirmative statements of government of rights.
So therefore, is America's, and again, I say this with quotation marks, is America's rejection of the general notion of positive rights born out of our rejection of British common law tradition and our desire for written constitutionalism?
I would say, I mean, that's a great question, David. I'd be prone to say, yeah. I mean, remember, there's a libertarian impulse at our founding. And I would suggest it's still with us. So, I mean, the founding had a lot to do with rejecting common law, legislative supremacy, governments dictating these things. So I think the founding did have that libertarian impulse at the founding is critical, I think, to your question.
That carries over to the 19th century too, because as we see that, Jim Crow in Jim Crow America, I mean, what's the case? It was Reese. I don't know. It was a voting rights case for African Americans, and the court said the 15th Amendment does not confer a positive right to vote. It simply says you cannot be denied the right to vote based upon these things. So if you can be denied the right to vote because you can't pass a literacy test or you can't pay a poll tax or grandfather clauses, so we see that the idea of negative or the lack of positive rights carrying over into the 19th century. This is why I think, honestly, I hate to jump to the presentism, but this is why I think it's imperative right now to get the voting rights reform taken care of. So we established that there is a positive right to vote for every person that qualifies, because there's too many workarounds with the idea of somehow limiting people's access to the polls. And we talk about. I'm sorry, David, go ahead.
Well, I'm just wondering, isn't that the general principle now after all the amendments and then and the Voting Rights Act, that in general everybody does, but the debate now is qualifications, because of course we have so much fraud out there that we need to clean it up. I mean, isn't that the general assumption now, Chris, is that everybody does have the right to vote if they're qualified? I
don't think so. I don't believe that's the case. I think back to Tim's word, disingenuous, for disingenuous reasons, you have people that are pushing this idea that there's not necessarily a positive right to vote. And that way they can actually limit those rights to vote at the state level. So I think that's why it's imperative, I believe, to get language within the document that says that there is a positive right to vote.
Well, has this positive negative distinction, has this been an ongoing debate in the history of our republic, or is it much more of a modern debate, really post-industrial revolution? Because I think a lot of the positivism that we talk about today comes in the form of economic access, economic equality, economic rights. I don't know if you call them rights. Am I right on that? And again, Tim,
no, I would say at the founding, they didn't use those words though, David, but I think at the founding, they talk about natural rights, retained rights, that government can't mess with these natural rights that I have. I mean, even the Federalists made that argument, that we don't need to list them because they're retained. But again, they didn't use those terms of positive liberty, negative liberty. But I think the debate was there, that these retained rights, these natural rights, you were immune from government action because you had these inherent rights.
Well, I mean, I look at the right to property. They don't phrase it in the Constitution or Bill of Rights in a positive sense. You cannot be denied your right to property without due process of law. That's not really a positive.
Well, but the reality is you don't know what property you have until governments make a decision on what property is. So the mere definition of property may be a positive right because it takes government to act.
Yeah, I mean, I think to me, it's the last phrase of the Fifth Amendment where they designate private property, right? Nor shall private property be taken for public use without just compensation. I mean, that's where, like in a lot of other constitutions, the constitutions are written in ways where it's like, all right, you have a right to health care and we demand the government use necessary available resources to make that happen. And here, I don't know if it's the only time, but they're talking about the government actually saying, we're going to take something from you. We're going to pay for it, right? It's nothing. That's more in line with the way these things are framed also.
Well, so is it fair to conclude that in modern constitutionalism, in the 21st century, that the most effective constitutional systems are going to have a balance of positive and negative rights? Is that a fair statement? Because so many of our problems are economic inequality, or a lack of economic equity, a lack of access. And the only way that can be dealt with, whether it's healthcare, whether it's education, whether it's employment, is with a statement of positive rights. We still want the negative rights, especially found in, as Mike says, in the First Amendment and to some degree in the Due Process Amendments. But the big debates today are economic. And the only way to deal with those really, are in the form of positive rights. Wouldn't you agree?
I'm not sure, honestly, because it sounds like, I keep thinking about the UDHR in the back of my head, or maybe even the South African, Constitution, which lists many positive rights. Is that correct, Mike?
Yep.
So yep. I guess I don't know the answer to that, David. I'll defer to my learned colleagues.
I don't either.
Okay, I'll dive in here. Okay, so what you're asking is, the United States Constitution, when looking as compared to other democratic constitutions, it looks a lot different in terms of how rights are articulated. I would say other constitutions do have a balance. And I think that that's partially our own particular culture. I think those on the European continent, the idea of the state and the role of the state, it's just understood differently at an earlier time than it is in the United States. And then I think as we look beyond Europe, after colonialism, we just look and see other countries now can look at different models. So yeah, I would say that our Constitution is unique in that we don't have a balance. I would argue we don't have a balance. And I would say most other democratic constitutions have a balance. But you know, the Constitution of China and Zimbabwe also have Bill of Rights. And students should remember that as well. That sometimes you can find these things in the documents, positive or negative, and they're not going to mean anything because the political elites are not going to allow them to mean anything.
Parchment barriers.
Yeah, very much so.
Yeah, there's a specific item in the Chinese Bill of Rights. It's wonderful. I think it's actually item 51. I'm paraphrasing. It's like it says, you have all of the rights that we just listed until we decide you don't. And they phrase it like goes against the security of the state or something like that. But it's like a wonderful Bill of Rights. And then you get the ultimate caveat in Statement 51.
Well, and I would argue, Tim, that maybe the Chinese are at least more honest and upfront about it. Because I would argue that at least through most of our history, that's been true in the United States. Yeah, you got these rights until we determine you don't. Especially to minority groups, whether they're racial minorities or they're political minorities or economic minorities, labor unions and things like that. The way it's played out is virtually the same. And I learned this from Dr. Williams. He was the first one, I think, to make a presentation about this notion of positive negative rights. And at the time he was referring to South Africa. And he said, the problem is when you write these, then the burden is on government to provide them. Yeah. And the question becomes a problem of resource allocation and how do they provide all this stuff? Well, I would argue that on the flip side, it's still true that if you have negative rights, how do you make that happen? I mean, isn't that the core fundamental question of the Fourth Amendment search and seizure clause? How do you make police abide by the Fourth Amendment, of which we grapple with all the time? So part of me says that whether positive or negative, the key question is how do you fulfill those promises or those guides there, Mike?
Yeah, no, I agree with that. And I would just say that in the American context, though, it's fascinating how leaders like Abraham Lincoln and then Martin Luther King would use the Declaration of Independence and use the preamble, talk about it as this solemn obligation that the government has. Like they turned those two parts of those documents into this notion of positive rights, forcing government to act. And I've always thought in the South African case, while it concerns me that people will lose legitimacy in government if they can't hold up these rights they're trying to do, it means a lot that they're written down and people can go to court and there's ways for them to get the government to act. So I think it is important to have them written down even when they may not be enforced right away, because it's setting up certain attitudes that citizens will have about the role of government.
Blake, go ahead, Mike. Go ahead, Tim.
David, I was thinking about your statement about it may not mean much until there's enforceability. And I was thinking about how we wrestle with, we have these statements about the equal protection under the law, but making that true, there's a raft of government action through policy to sort out how that works. There's a whole legal set of legal doctrines and judicial standards to make our commitment to equity possible. So I think your point's well taken, that the distinction may be without a distinction short of enforcement of the principles. And that often takes a whole scaffolding of government action.
Right. And I think positive and negative.
I'm sorry, Chris, go ahead.
Yeah.
No, I was good. Go ahead, Dave.
I think positive, negative, it's one of the topics, I guess it's now in Unit 3, used to be in the old book, the Unit 4, of this notion of equality of opportunity versus equality of condition, which I think is a wonderful framework, to get kids to talk about. Can you have true equality with disparate conditions, which we have struggled with as a nation? And I think Mike's absolutely right. Europe, Canada, Australia, they've approached it very differently in their history. To me, they've come to accept that, the notion that you cannot have equality of opportunity without some element of equality of condition in various sectors of their society. And so, again, I always loved having that conversation with kids. Chris, you were going to say something.
Well, no, I was thinking, I'm just listening to you guys, and I just had this discussion today talking. We had read some Webb Du Bois and Booker T. Washington, right? And in a nutshell, Booker T, the reality of living in Alabama, the reality of being born a slave in Virginia, right, the outset of the Civil War, is that we're not going to stir things up, because we understand that that's a problem. If we stir things up, we agitate, that's a problem. Then Webb Du Bois, born into a middle-class Black family in Massachusetts, and goes to Harvard. He's like, why should I wait? I don't have to wait. I'm a citizen. I'm entitled to these rights. The Declaration says the purpose of government is to secure these rights. So it's and King writes about this in a letter from Birmingham jail, the rule of law versus rule by law, talking about what's going on in Alabama. They're expecting Black folks in Alabama to live by these laws, but they're not holding the white people accountable to these laws. So, I don't know where I'm going with this, but there's a problem in there in terms of enforcement and accountability to different groups of people throughout our nation's history. So we think we have these rights, but until we can actually hold the government accountable for enforcing these rights on an equitable fashion, it may not even matter. And this has been the ongoing struggle, and we're still struggling with it to this very day.
Well, I think that's a good note to bring our session to an end. I do want to give everybody a chance to, if they have anything to say in closing, to hopefully students, you've seen over the course of our sessions together that these are not easy questions. With when I ask questions to two of the very best in the country on these subjects, and they kind of go, well, I don't really have an answer or an opinion on that. That tells you how complex some of these issues are, and that you're being asked to handle some things that most adults in this country can't handle. I would suggest that you not be afraid, all right, to go up against a Professor Moore and his love of the anti-federalists when it comes to the Bill of Rights, and take the Madisonian perspective, because I'm one to argue that in the scheme of history, Madison was right, and I think there's a legitimacy there. Then again, I am the dumbbell of the group, but don't be afraid to take on, because again, the common view is, and I think this has been brought out in this group, there is this cultural love of the Bill of Rights without having a lot of knowledge of the Bill of Rights within the context of our constitutional system. So saying, oh no, we don't need it, it might be blasphemy in our civic religion there. So those are some things to think about. Mike, any closing thoughts?
Yeah, I would just leave the students with, as important as Bill of Rights are, whether positive or negative, a lot of this just comes down to the politics, right? It doesn't matter whether it's the Bill of Rights or not. Congress, states, local municipalities, they can reform how police operate. All the Bill of Rights are doing is of giving the bare minimum of what government can't do to you. So I would just encourage you to utilize that most important right that Chris mentioned, and to think about that most important right, the right to vote, and then the right to have ways to address inequality and inequity through the politics of it, and not necessarily just wish that we had a different set of rights, because that wouldn't fix the problem.
Chris?
I would direct the students to the very beginning of the book, and one of the opening exercises before you even get into Unit 1, and there's a exercise with learned hand, and the idea that, you know, if people don't believe this stuff in their hearts and in their minds, you can list all this stuff on whatever you want to list it on. It's not going to matter, right? Until we buy into the idea that everyone should in this nation should have access to and protection from these rights, it's not going to matter until we believe it, right? So, but I would go back and read Learned Hand's Spirit of Liberty speech, because I think that will really help you. And I'm not going to get all geeked out and, you know, on that, but it's good stuff.
Mr. Moore?
No, other than to say, be prepared for the judge who says, ask some kind of question like about all the rights, which is the most important. Don't fall for that. Or at a minimum, if you got 4 people on the panel, take 4 different ones. Do that.
Well, of course, they're the ones in the first, because they're first, Mr. Moore.
Hunting,
right.
hunting.
Don't do that.
Cheese curds. Hunting, fishing, cheese curds. Say that.
And that's a good point, because the chances are they just may get that there. So next week, teachers and students, will be our last session for the national questions. We're looking forward to it. We're going to be talking about Unit 6, Question 2 on foreign policy, and we will have a guest, another Badger from the University of Wisconsin, to join the 4 Bs to talk about American foreign policy and the Constitution. So we look forward to that. Until then, have a good day, good week, and we'll see you next time. Same bat time, same bat place. Peace, love, yogurt tacos.